Good evening.
Good evening, Council. My name is Kevin Bragg. I'm from the law firm of Dinsmore & Scholl in Dayton, Ohio. My home address is 9055 O'Connors Point Drive in Bell Center, Ohio. Thank you for the opportunity to address the Council tonight. I'm here on behalf of Garden Manor to bring out some facts to the Council's for their consideration. The first fact that I think the Council needs to consider about the proposed zone change and the proposed coke plant that is contemplated to take advantage of that change is that it just doesn't fit on the property. The Middletown City zoning code, as Mr. Kohler so ably pointed out, requires a 600-foot setback. During the Planning Commission's hearing, request for materials, SunCoke presented a drawing of their site, as was requested by the Planning Commission and others. And we have examined that drawing. I've submitted it in the materials that I submitted to the Council earlier in this week. And that drawing at least will violate the 600-foot setbacks. So I do not think that there is any evidence that has been presented by SunCoke that would show that this coke plant could fit on this property as it is currently contemplated. It is the Council's duty to, I think, consider all the known facts about this in determining the rezoning. I think it is to consciously ignore known facts would be the essence of an arbitrary and capricious consideration. And as the facts are before the Council, it is known that the coke plant won't fit on the property right now. And so on that basis, we think the zoning change should be denied, or at the very least, it should be sent back to the Planning Commission. And SunCoke, of a project of this magnitude, should put forth a plan that can be examined by the neighbors, including Garden Manor, which is, again, a large employer within Middletown, one of the top 5 or 6 employers in Middletown, to make sure that this is going to be able to comply with the well-established zoning code. SunCoke has said in that their materials that they presented to the Planning Commission in a letter that they can't move it where it is on the facility. If that's the case, it is never going to fit on the property as the law is written right now, and the zoning change should just be denied then on that basis. The other issue that I wanted to bring up and that I addressed in the materials I submitted to Council are the air issues. The air issues in examination of the permit application that SunCoke has put before the Ohio EPA, and I'm aware that you're not the Ohio EPA, indicates that the actual number in terms of the amount of pollution that SunCoke will introduce to the Middletown air is somewhere above 2,800 tons of new pollution. However, SunCoke doesn't count all of this pollution. They have engaged in what's known as a netting exercise in which they are claiming credits for AK Steel's past shutdown of what was their sinter plant. It was a recycling plant for coal dust, things of that nature. I haven't heard any discussion from SunCoke about the netting aspect of this plan. All I've heard is this is better technology, this is environmentally friendly. But the fact of the matter is, and this is a fact that I have not heard anyone deny, is that the reality is there will be 2,800 tons of new pollution. Not all of it will be counted if SunCoke is able to do that in this manner. Just so you have a frame of reference of what that means, the significant pollution level under the federal law for the pollutant particulate matter 2.5, which is a tiny, one might even say microscopic particulate. The significant threshold for that is 15 tons of pollution a year. SunCoke's permit indicates that they'll emit 244 tons of pollution a year. That's 16 times the significant threshold. Yet they consider this a minor modification with no significant increase in air pollution. For sulfur dioxide, which is a precursor to acid rain, the significant level is 40 tons of pollution. The permit indicates that SunCoke will emit 1,584.7 tons of sulfur dioxide. That's 40 times the significant level. For nitrogen oxides, the significant level is, again, 40 tons per year. the permit indicates, SunCoke will indicate 484.7 tons of that pollutant. That's 12 times, again, the significant level. So what does all this mean? Well, it means that I guess it's cheap to pollute in Middletown. I mean, that's a good if I were running a business, I'd be looking for that too, as a good place to pollute. If we can pollute cheaper in Middletown than we can pollute somewhere else, that certainly will factor into anybody's business calculation. But we should consider this as we're considering the zoning change. SunCoke, it appears, is trying to acquire an inexpensive right to pollute. But of course, that pollution, there will be costs for that, and they will be borne by people. And one of the major bearers of those costs will be Garden Manor and their 500 residents who are elderly and vulnerable, as well as their employees. It also will be the children at Amanda Elementary School across the way on the other side of the Bake Martin property. Again, a group that the U.S. EPA considers to be a vulnerable population. The question of whether or not this can be done legally is an open question. I looked at a few things, and what the U.S. EPA's New Source Review Workshop Manual says, and it's a pretty impressive document if you're just doing it on weight. What it says is the consideration of contemporaneous emission changes is also source-specific. Netting must take place at the same stationary source. Emissions reductions cannot be traded between stationary sources. So I think that is an open question as to whether or not that is even permissible under the Federal Clean Air Act. Again, SunCoke, during the planning stage of this, never mentioned anything about netting. All we heard about was environmentally friendly, better technology. And after the public hearing was closed, some members of the Planning Commission made a field trip to Haverhill and came back and told everyone that there was nothing to fear, that they had worn white gloves during their visit, and they were clean when they came back. With all due respect to the Planning Commission, that is not a valid or legitimate way for determining this air issue or having a debate about this. This is a drawing that was handed out by Bob Bodenbosey, who's with the Air Agency in Ohio EPA.
Stay close to the mic. They won't be able to pick you up otherwise. Thank you.
That at the most recent Ohio State Bar Association environmental seminar at Deer Creek Lake State Park. And as you can see from this, it says, how small is PM 2.5? What you see right here, this cylinder blown up drawing, is the diameter of a human hair. Okay, so if I pulled out one of my hairs and you looked at the diameter of that hair, that's what a cross-section of it, that's what you'd be looking at right there. These little specks that you can barely see under the microscope are the diameter of PM 10 and PM 2.5, which are air pollutants that can lodge in a person's lungs, create the hardening of the arteries and heart attacks. So I would submit to you that the Planning Commission's efforts to go to Haverhill, while noble and admirable, were undermined by the fact that their science wasn't very good with their white glove test. And there was never an opportunity for anyone to address this because the public hearing was closed. We couldn't bring this up to the Planning Commission. The other thing that in the short amount of time that we've been working on this, is we were able to secure from the local air agency in Portsmouth some of the complaints and malfunction reports regarding Haverhill. And I have here with me the malfunction reports in this hand, and we've got some of the complaints from the residents down there. And I just think that in order to have a fair picture of it, that we should read a few of these for council's consideration. There was a complaint lodged with the Portsmouth Local Air Agency November 27th, 2005 by Michael Floyd of Franklin Furnace, Ohio. That was during a known malfunction event at Haverhill. It said, Mr. Michael Floyd left a message on the agency answering machine and also called Ohio EPA emergency response. I phoned Mr. Floyd to get more information. He said he couldn't go outside Sunday because of the odor. He said it got better in the evening. The wind direction had changed. I explained the malfunction event to Mr. Floyd. He said they shouldn't be able to bypass indefinitely. Around that same time, On November 29th, a couple days later, Kelly Graff of Franklin Furnace again called the Portsmouth Local Air Agency. And the report says, Kelly Graff called and stated odor was so bad on Sunday she couldn't breathe and her porch was covered with dust. She said after they load the rail cars, there is steam or smoke rolling off of the cars. She said the odor is bad night and day. She has 2 horses with a chronic cough. I told her we were doing everything per the regulations. I don't have the authority to shut them down. The plant had a malfunction event and we're bypassing. On July 20th of 2005, Kelly Graff again called to complain. It says Kelly Graff called to complain of black dust on property from coke plant. I met with Kelly Graff at her residence at 2013 Back Road. Kelly showed me the black dust on her porch facing Back Road. The window seal was covered with black dust, a few days old. I took pictures of the window seal and porch swing. I went to the residence of Jack and Peggy Maddox with Kelly, about a quarter mile west on Back Road from Kelly's house, to look at their in-ground pool. I could see black particles on bottom of pool. They said was just swept yesterday. They said there was black dust on property and vehicles daily. They said there was white dust occasionally, dusted vehicles. They have had some dust from trains, but not like this. On July 5th of 2005, an Angela Brewer called to complain of a white ash in the air. She said it occurred between 11:15 and 11:30 today and also happened a few weeks ago. I called Miss Brewer to get more information. She said it looked like a snowstorm. She said it was from the east towards her house. It was a fine white ash. She said it happened about 3 weeks ago, but was worse this time. She said the pool was full of ash and just spent $100 on chemicals. And then finally, on February 7th of 2006, a Rick Sealhurst, who is identified with the Kentucky EPA and an address in Salome, Kentucky, complained to the Portsmouth Local Air Agency. On January 28th, 2006, coke odor present from 7 to 10 p.m. in Salome, Kentucky, approximately 11 miles from Haverhill North coke plants. The odor was so strong that he could smell on his clothes when he went home. There was a very strong southeast wind that night. Mr. Sealhorst stating that he is a coke plant inspector and knows the coke odor. So, with all due respect to the Planning Commission, it seems they were there on a good day. There'll be good days. There'll be bad days. The question is, how many bad days do you have to tolerate when you're a neighbor, when you live at Garden Manor, you're a resident in a vulnerable community? But maybe it's just inconvenient, Maybe I'm just, maybe people just have to, suck it up sometimes and tough it out. But the thing is that there are health studies out there. There are health studies out there about PM 2.5. There are health studies out there about ozone that is formed by nitrogen oxides and sulfur dioxide. And these health studies are not good. And as we stand here right now, they're unrebutted. I'd be happy to have an open discussion of these with people from SunCoke. I haven't had that opportunity yet. But in materials I included with you, the Journal of the American Medical Association published a study. Can't find a more reputable journal than the Journal of the American Medical Association that pointed out that ingestion of PM 2.5 leads to the hardening of the arteries and heart attacks, and states even short-term exposure at elevated concentrations can contribute to heart disease. Ozone, it's well documented, contributes to asthma in children. The children are particularly susceptible to increases in ozone because their lungs are developing. They spend more time outside playing than we do as adults. We spend our time in our offices. They're outside playing. Children of the Manor Elementary School are right across the way there. So there are real concerns here that should be addressed, that should be looked at and studied and considered. I appreciate that business goes forward and no one likes progress better than me. But there are some real issues here that should have a meaningful dialogue, and there should not be a rush to judgment. And that's what Garden Manor is afraid is happening here, that we're having a rush to judgment. There's no reason for it. So it's our position, based on all of this, that Garden Manor's position that the zoning change should be denied, and that if it is within the desire of the council to send it back to the Planning Commission for further discussion and a meaningful exchange on these issues, we'd be happy to participate in that. Thank you very much. I would take any questions if anyone had.
Any questions this evening?